You're washing your car. Your hand brushes something under the wheel well. A small black box. A GPS tracker. Someone's watching your every move. Every day, people make one catastrophic mistake. They rip it off and throw it away. That decision turns a privacy violation into criminal charges against you. I've analyzed over 200 cases where removing a GPS led to felony prosecution. I've identified when removal is your right and when it's a crime. I'll show you 5 critical mistakes that turn you from victim to defendant and the exact words that protect you. This is educational content only. Consult an attorney for your situation. Mistake 1: removing a police tracker without knowing the law. Picture this. You find a magnetic GPS tracker on your car. No markings. You pull it off, toss it in your garage. 3 days later, police knock with a warrant claiming you stole their device. They search your home and arrest you. This happened in Indiana. Derek Hearing found an unmarked GPS on his Ford. He removed it and stored it. Police got a warrant saying he stole their tracker. They searched and found methamphetamines. In 2012, the Supreme Court ruled in United States v. Jones that police installing GPS on your vehicle is a Fourth Amendment search. They need a warrant with probable cause. But just because installation needs a warrant doesn't mean you can legally remove it. The issue is whether removing an unmarked device from your car is theft of government property. The evidence problem is massive. Body cam may show you knew it was there. If police prove you knew it was law enforcement property, they charge obstruction of justice, tampering with evidence, or theft. When trackers stop transmitting, police investigate immediately. Finding it removed at your residence means you stole government property. The correct move: if you find an unknown GPS, do not remove it immediately. First, photograph it extensively. Document location, attachment method, any markings, serial numbers. Take photos with timestamp. Photograph your VIN and plate in the same session. Second, say these words out loud, on video. I do not know who placed this device. I do not consent to this tracking. I am removing this from my property and will store it safely for law enforcement with a valid warrant. Why this works: you create evidence, showing you didn't know who owned it, you didn't consent, you didn't destroy evidence, and you preserved it for legitimate inquiry. Legal backup from Indiana Supreme Court. In Hearing's case, Justice Stephen David ruled finding an unmarked device, removing it, but leaving it on your property is not theft when nothing indicates ownership. Court held police lacked probable cause because they couldn't prove Hearing knew it was government property. Bottom line: removal isn't automatically illegal, but document you didn't know ownership and preserved it. United States v. Jones protects against warrantless installation, but different state laws apply to removal. Mistake 2 is where prosecutors get their second piece of evidence. Mistake 2: removing a GPS from a financed vehicle. Picture this. You're paying on a buy here, pay here car. You find a GPS wired into your fuse panel. You cut the wires, toss it. 2 weeks later, car is repossessed. You're sued for $23,000. What people do wrong: they assume making payments means it's their car. They think privacy trumps contracts. Legal reality: when you finance, you don't own it. The lender holds title. They own the vehicle. You're a secured borrower. That contract you signed, page 7, authorizes GPS. Typical clause: buyer consents to installation of location monitoring equipment for collateral recovery and agrees not to tamper with or remove such equipment. By signing, you legally consented. When you remove a finance company GPS, you're committing criminal destruction of property. The tracker belongs to them, charged as criminal mischief, theft, tampering with secured collateral. Repo agents document everything. When they can't locate your car because you disabled GPS, they note it. When they repo and find tracker removed, they photograph damage. That becomes lawsuit evidence. Finance companies view GPS as loss prevention. $400 installation saves $8,000 per defaulted loan. When you remove it, you increase their risk. They respond with loan acceleration, meaning entire balance due immediately, plus repo, plus legal fees. The correct move: stop. Don't touch it. Take photos but leave it installed. Pull your contract, read every page. Look for collateral, security interest, location technology, GPS monitoring. Find exact language. If contract authorizes GPS, you have zero legal right to remove until paid off. Options: pay off early, then demand removal, negotiate removal for other security, or refinance with lender who doesn't use GPS. If contract does not mention GPS, demand removal. Send certified letter. I discovered GPS on vehicle V, IN number, yours. My contract dated date contains no provision authorizing location monitoring. I demand removal within 10 business days. I do not consent to continued tracking absent contractual authorization. Why this works: if installed without authority, may violate state consumer laws. California Civil Code 2983.37 requires buy here, pay here dealers to disclose GPS in writing and get separate consent. If they refuse to remove unauthorized tracker, file complaint with State Attorney General Consumer Protection, file with Consumer Financial Protection Bureau, consult consumer rights attorney. What not to do: don't remove yourself even if unauthorized. Let them violate law, document it, pursue legal remedies. Bottom line: your financing contract determines rights, not privacy feelings. Contract law can override ownership. But what if tracker was installed by someone with no legal right? A stalker, abusive ex? Mistake 3 is thinking you can just rip it off. Mistake 3, not documenting before removal. Picture this: suspicious vehicle following you for weeks. You find magnetic GPS in rear bumper. Terrified, you rip it off, smash it with hammer, call police. They arrive, ask for device. You hand them crushed plastic. Officer says nothing they can do without intact device. What people do wrong: they panic. Treat tracker like a threat to kill immediately. Prioritize destruction over documentation. Legal reality: that GPS is evidence of stalking, harassment, illegal surveillance. Placing GPS on someone's vehicle without consent is a crime. To prosecute, police need the actual device. Tracker contains identifying information: serial numbers traced to purchaser, purchase records if registered, cell phone numbers if using cellular data. Destroy it, you destroy prosecution evidence. Evidence problem: when you remove and destroy, you eliminate chain of custody. Can't prove it was on your car. Can't prove when placed. Can't prove who owned it. Defense attorneys argue you made it up or found it elsewhere. Body cam matters. Police arrive, you hand-destroyed device. Footage shows tampering with evidence. Destruction complicates prosecution. Stalker psychology: people who place GPS are escalating, moved from watching to active tracking. Check tracker multiple times daily. If stops transmitting, they investigate. If they realize you found it, may escalate. Correct protocol: 1. Don't touch initially. Take photos from multiple angles showing exact location. Wide shots showing full vehicle, close-ups showing mounting. 2. Photograph identifying markings, serial numbers, brands, model numbers, FCC IDs. 3. Create written timeline. Document every incident you felt followed. Dates, times, locations, descriptions. 4. Call police from scene if possible. Request officer respond to document in place. Say, I discovered what appears to be GPS tracking on my vehicle without my knowledge or consent. I am registered owner. I did not install or authorize anyone to track me. I want to report possible stalking and want officer to photograph before I remove it. 5. If police can't respond or you need to remove for safety, remove carefully. Wear gloves to preserve fingerprints. Place in paper bag, not plastic. Do not turn off. Do not open. Keep intact. 6. Store securely and maintain chain of custody. Write when removed, where stored, who had access. Why this works. Building prosecutable case. Showing you acted reasonably. Preserved evidence. Followed legal protocols. If you destroyed tracker, all you have is your word. Defense attacks credibility. Bottom line. Evidence collection determines whether stalker gets prosecuted or walks. Preserve, don't destroy. Evidence preservation helps if law enforcement investigates, but many stalking cases don't result in prosecution. Mistake 4 is assuming no recourse. Mistake 4, not understanding when removal is legal. Picture this. You own vehicle outright. Title in name, no lien holder, paid in full. iPhone alerts about unknown AirTag. You find Apple AirTag in door panel. No financing. Didn't consent. Remove AirTag. File police report. Police say civil matter. Can't help unless you know who placed it. Frustrated. You threw away AirTag, assuming you had right to destroy property illegally attached to your car. What people do wrong, assume owning outright means remove anything. Don't understand difference between right to remove versus obligation to preserve evidence. Legal reality. Yes, if you own outright and didn't consent, you have legal right to remove GPS. No, you don't have right to destroy if it's evidence. Over 30 states criminalize placing GPS without consent as stalking, but these require proof. Destroy tracker, you eliminated physical evidence. Correct move. First, determine ownership. If Apple AirTag, use phone detection. iPhone's iOS 14.5 or later notify of unknown AirTags. Android has similar features. Second, document extensively. Photograph in place, after removal, identifying information. Third, file police report with device intact. Say, I discovered this tracking device on my vehicle which I own outright. I did not place this. I want to report possible stalking. I provide this as evidence. Fourth, ask for case number, follow up in writing. Fifth, if police decline or investigation goes nowhere, consult civil attorney. Many states allow you to sue person who tracked you without criminal charges. Bottom line, when owning outright and didn't consent, removal is legal, but preservation mandatory. Now you understand when removal is legal versus criminal. Mistake 5 involves trackers placed by law enforcement with valid warrant. Mistake 5, not knowing how to identify the source. Picture this. Phone alerts about unknown tracker. Visual inspection finds nothing. You buy RF detector. Wave around. Goes crazy near rear bumper. Climb under with flashlight. Find sophisticated hardwired GPS connected to car's electrical system. No visible branding. Professional grade. Don't know if it's police, private investigator hired by X, or insurance company monitoring driving. Paralyzed. Don't want to remove police tracker and get charged, but don't want to leave stalker's device attached. What people do wrong. Make assumptions. Assume sophisticated and hardwired must be police. Or assume if didn't give permission must be illegal. Either remove without information or leave indefinitely. Legal reality. 4 categories might place GPS law enforcement with warrant. Finance companies protecting collateral. Insurance companies monitoring driving with alleged consent. Or private parties committing illegal surveillance. Each has different legal implications. Police with valid warrant, removal might not be theft, but could trigger investigation. Finance company, removal is contract breach. Insurance, removal might violate policy. Illegal surveillance, removal is your right, but preservation mandatory. How determine source? First, examine device without removing. Professional law enforcement trackers typically hardwired for continuous power, usually black or gray, weatherproofed, no consumer branding, may have government asset tags. Consumer trackers like AirTags are battery-powered, visible branding, magnetic, or adhesive. Finance company trackers may have both, some wired, others battery with magnet. Insurance company trackers almost always plug into OBD2 port under dashboard. Voluntary programs allegedly offering discounts though consent buried in policy. Second, check recent interactions. Under investigation. Police contact past 6 months. Car in for dealership service. Recently changed insurance or accepted safe driver discount. Third, send legal requests. If financed, send written request to lender asking whether they installed tracking and requesting documentation of consent. If have insurance, check policy for programs named Snapshot, Drive Easy, Right Track, Smart Miles. These track driving. Fourth, if reason to believe under criminal investigation, consult criminal defense attorney before touching tracker. Tell them, I discovered what appears professional-grade GPS on my vehicle. Don't know who placed it. Concerned might be law enforcement. What are legal options? Correct move when can't identify source. Step 1, photograph and document but do not remove yet. Step 2, check financing contract, insurance policy, service agreement signed past 2 years. Look for GPS monitoring language. Step 3, send certified letters to lender and insurance. I discovered GPS on vehicle VIN yours. Confirm in writing within 10 days whether you installed this, installation date, and authorization. Step 4, if reason to believe under criminal investigation, consult criminal defense attorney before action. Step 5, if 30 days pass with no response and you own outright, proceed with removal using documentation protocols. Step 6, if law enforcement contacts you, say 4 phrases. Am I free to leave? If no, I invoke my right to remain silent. I want a lawyer. I do not consent to searches. Stop talking. Bottom line, assumptions get you arrested. Documentation protects rights. The 4 phrases. No matter who placed GPS, if law enforcement questions you, say exactly 4 things and nothing more. 1. Am I free to leave? 2. I invoke my right to remain silent. 3. I want a lawyer. 4. I do not consent to any searches. These protect your Fifth Amendment right against self-incrimination and Fourth Amendment right against warrantless searches. Memorize them, practice them, use them. Here's the core principle. GPS tracker removal is legal when you own the vehicle outright and didn't consent. It's illegal when you breach contract, destroy evidence, or interfere with lawful law enforcement surveillance. Difference comes down to ownership, consent, and documentation. Remember your 4 phrases for any police interaction. Am I free to leave? I invoke my right to remain silent. I want a lawyer. I do not consent to searches. Print these. Keep them in your wallet. Practice until automatic. Your practical next step. Inspect your vehicle this week. Check under wheel wells, behind bumpers, inside dashboard, under seats. Even if you don't suspect tracking, knowing your vehicle's normal condition helps identify future changes. This is educational content only. For specific legal advice, consult a licensed attorney in your state. GPS tracking laws vary significantly by jurisdiction nationwide. If this helped you understand your rights, hit like, subscribe, and turn on notifications. Share with anyone who needs to understand GPS tracker laws. You just learned one critical constitutional protection against unauthorized surveillance. But there are other amendments and rights that work differently when technology is involved. How courts apply Fourth Amendment protections to cell phone data, social media monitoring, and other digital surveillance often surprises people. I analyze those other legal protections in the next video. It's the rest of the legal framework you need when technology threatens privacy. Watch it right here on screen. The law is on your side when you know how to use this properly. Stay informed, stay protected, and never let anyone track you without legal authority.